Michael, have you ever had a client come to you with an objective that you don't think is reasonable or possible?
Almost half the clients that come into the door, I've seen relationships with lawyers break down because of that. And it's a really important thing for lawyers to keep in mind, but also I think very reasonable for clients to say, all right, well, how are you as my lawyer going to make sure you're able to capitalise on that later in the dispute?
Hi, I'm Christine Turkington.
And I'm Michael Buscema. We're from Aptum, and today we're talking about some of the challenges clients experience with services and litigation. So in our role as lawyers, in terms of setting the expectations on what we can deliver, how do you try to make sure that you're addressing all those competing goals in terms of how you can sort of deliver services to the client?
Well, I think that it's just important to touch base with the client as often as possible. And that's, part of our way that we work at Aptum is to work with the client to form that strategy. And if you're constantly touching base, it allows you to figure out ways to get both of those goals and to also prioritize those goals and see how the client is prioritizing those goals for themselves.
Do you think there's anything that lawyers can do, or on the other hand, that clients can ask their lawyers to try to either predict or identify as early as possible what could happen so they can try to imagine how their goals could change over time?
I think that is what's really important about doing kind of a legal pathways assessment, is to explore all the different avenues that could be possible. And the outcome of those, that it can also help a client to more clearly identify what their goals are. Because if you take them down one pathway and you say this is the result, and then if you go down this pathway, this is the slightly different result, they can maybe more easily be able to identify which result they would prefer, and that can help them identify more clearly what their goals are if they are struggling to do that.
Do you find that clients sometimes are reluctant to get a broader advice on their pathways at the start because they have a very strict idea in their head of the outcome they want? And if so, how do you help the client overcome that so they better understand their options?
Often clients do come with a preconceived idea of what they want. At Aptum, we don't always necessarily even give strictly legal pathways. Some of them might be alternative pathways outside of litigation that could be used to resolve the dispute. And it's very surprising how often clients haven't thought about those alternative pathways for early resolution, which are available to them, and that can be very useful to them as well. Michael, have you ever had a client come to you with an objective that you don't think is reasonable or possible to achieve? And how did you deal with that?
I think it's important for lawyers to be very upfront with clients around the scope in which they can help and what we would call our duty to the court, but being very clear practically with the client to say, we can't just run any old case to try to just maximise what you could possibly get. We need a proper basis to be able to ask for the things or demand the things that you think you want. And within that, we need to be able to put forward a reasonable position. If we have a view that something isn't a reasonable position, it's best to identify that with the client early so they can consider what their other options are. But in that, you have to be able to explain to the client the reasoning why you think that isn't a reasonable request, but also give them other options and explain to them in these sort of circumstances what they could otherwise get in the situation. If the client isn't happy with that at the start, then at least you've broached that topic early. If they want to consider other pathways, they can. But it means then if you continue to represent them as a lawyer, you should then be on the same page in terms of what's a realistic option. It's always problematic if you don't address it at the start. And in your head as a lawyer, you think, well, I'm not going to get what they want, but I'll hopefully get them something, because you could then get to the end and the client says, hang on, I thought I was going to get X amount, but now I've only got Y amount. You want to avoid that situation.
And also what's important to understand, and what is sometimes difficult to communicate, is the value that things have in the long run. It can be easy to understand why something's important, why we need to appear at the trial because it's important there and then. Yeah. But sometimes the work that you're doing, even early on in the case, right at the beginning, is important for the trial all the way at the end. And to communicate that value to the client. So yes, we're taking time now to review all of this, and we're putting in extra time on the letter of demand and the statement of claim. You may not understand now why we have to review all these documents in such detail, but when it comes to the trial, it's very important, even though that trial is 2 years away.
I think that's really important, but I think it's also a matter of the trust being earned. It's really important that your project management framework of how you actually manage the litigation, yes, allows you to bring work forward because it provides value over the life of the dispute, but you need to be able to utilize that through the dispute so you're actually saving time and cost. I've seen relationships with lawyers break down because of that, and it's a really important thing for lawyers to keep in mind, but also I think very reasonable for clients to say, all right, well, how are you as my lawyer going to make sure you're able to capitalize on that later in the dispute? How do you go about positioning a client so that they're comfortable in making a decision themselves based on the advice you're giving them, rather than them felt like they're being led to an outcome?
Well, it's important that they are aware of the risks as well as the beneficial outcomes of the decision. We actually recently had a matter where we were deciding whether to go to summary judgment or not. That's a very big decision for a client to make, and there are very clear risks and benefits associated with it. But at the end of the day, it was a decision that the client makes. We also, we look at litigation as an investment for clients, and so only they can know how much they're willing to invest and how much risk they're willing to take on their investment. But we also didn't shy away from giving an opinion. And I think that that's important to still give that opinion. I think some people are just like, these are the risks, these are the benefits, make your decision. They are coming to you for your advice and for your opinion. So it's important that they have all three, the risks, the benefits, and what you would advise, so that they're able to make that decision for themselves.
Yeah, clients should expect that their lawyers can give them a recommendation. It's not simply enough to say, here are the positives and negatives, you go forward. And part of it, I think, leads to what you were saying before about, well, if you were to take this decision, how does that align with the ultimate objective? And I think that helps a client be able to feel more comfortable with making a decision, because they're not assessing it against some hypothetical situation that might never occur. They're assessing it against all of their other reasonable decisions to make.
I think that people have a good understanding, when you're explaining financial risks, emotional risks.
I think that you, as a lawyer, you obviously need to be careful not to use language that's not understood by the client or not accessible, sort of legal language that leads them to feel confused. But I think it's important that you're able to explain options and processes so that they're at least aware of what they are and what they practically mean. Because if they're not understanding of the process or how those systems work in their dispute, then it's going to be very difficult for them to make an informed decision on it. So I think the job as a lawyer is not to shy away necessarily from the process or the complexity and explaining that to the client. I think it's important that you actually have to do that, because you get the buy-in from the client that they're actually involved in the process. I think it's more though about being able to explain it in a language in a way that you didn't necessarily learn in law school or you're accustomed to in speaking to other lawyers. I think it's very outcome-based. What is the implication of each of these steps in the process that helps the client understand? And you're right, because that then gives them a framework to understand their financial risk, emotional risk, and what decision they make based on their investment.